The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name's Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain irrevocable trusts. We'll first explain what a trust is, and then we'll talk about the difference between an irrevocable trust and a revocable trust, and finally we'll talk about the different purposes that irrevocable trusts are used for. So a trust is both a document that leaves instructions for how property is to be handled, and it also is a legal entity that can own property separate and apart from its creator. The creator of a trust is known as the grantor. So we're going to use that term a lot when we talk. We're going to talk about a grantor, and that's the person who made the trust. The grantor will name trustees and successor trustees that act in order of succession to manage the assets that are owned by the trust according to the trust terms for the benefit of beneficiaries. The grantor of the trust will also lay out a beneficiary structure that can have multiple contingencies, saying basically in certain situations, if certain things happen, here are the people that I want to benefit from the assets held by the trust and how I want them to benefit. And those instructions are left in the trust document for the trustee to manage. So those are the three people that we're talking about: a grantor, a trustee, and a beneficiary. And in a revocable trust situation, they can often start out as the same person. The grantor can be the trustee and the beneficiary of his or her own trust until he or she passes away, and then other beneficiaries and trustees take over. In an irrevocable trust situation, they're usually different people. So let's talk about the difference between a revocable trust and an irrevocable trust. In a revocable trust, the grantor, remember the creator, retains control over the trust while he or she is still mentally competent and alive. So as long as he or she has her mental faculties and is still living, the trust can be revoked, modified. Really, for most intents and purposes during this period, the assets of the trust are considered to be really owned by the grantor for tax purposes, things like that. The benefits of a revocable trust kick in once the grantor passes away, generally. There are some benefits that occur during the grantor's lifetime, but most of the benefits occur once the grantor either passes away or becomes mentally incompetent to manage those assets. These can include eliminating the need for a guardianship proceeding in the case of incompetency, management of the investment and distribution of assets after the grantor passes away or becomes mentally incompetent, and avoiding probate when the grantor passes away. And we have a lot of videos and articles about probate avoidance and revocable trust and how that works. So the revocable trust is basically, it's a low-stake situation when someone creates a revocable trust. It's when most people go to their attorney to get a will done. If they own any amount of assets or any real estate, they're generally steered in the direction of a revocable trust instead of a will, because there's really no downside to it. They're not giving up any control during their lifetimes. An irrevocable trust requires the grantor to permanently give up some control of the assets in order to receive the benefit of the trust. It can't be revoked or modified unilaterally by the grantor, and the assets are no longer considered, for most intents and purposes, owned by the grantor. The trust is taxed separately, and for most purposes, it's not nudge, nudge, wink, wink, there's a trust, but it's really the grantor's assets. The assets are now trust assets, and the grantor may retain some rights in them, but they're no longer the grantor's assets. So why would someone want to give up control over assets during their lifetime? Let's talk about what irrevocable trusts are used for. They do things that are different from the standard estate administration and probate avoidance of a revocable trust. For one, they protect assets from creditors during the grantor's lifetime. So you can use a revocable trust because you're giving up some control over the assets to allow creditors not to access them. And this is often done within a family, giving your children some rights to the assets immediately rather than just inheritance rights. They can also remove the assets from the grantor's estate for the purpose of estate tax while still allowing the grantor to retain some control over the assets during his or her lifetime. So we say that it's irrevocable. You can't change the terms of the trust, but you can bake into the terms of the trust a certain amount of control during your lifetime as long as you respect the rights of the beneficiaries of the trust that you've named other than yourself. And when you do this properly, they're not the assets that are owned by the trust are not considered part of your estate for estate tax purposes. Now, this is very complicated, and we have a specific article and video about how to plan for estate tax using irrevocable trust, so check that out. And the other purposes here we're talking about, we have specific articles and videos going into detail about how they're used. So we're going to talk pretty briefly now, but if you're curious about any of these purposes of irrevocable trust, go to learn-about-law.com and see the videos. Another use of an irrevocable trust is through something called a grit, grat, or groot. These are grantor retained income trusts, annuity trusts, and unit trusts. And what these do, they're often used for business and real estate, and they allow the grantor to transfer one of these types of assets into the trust. And it can be any type of assets, but this is the most common use. And they allow that asset to accumulate in value over time while still allowing the grantor to retain some income, receive some income from the asset, and retain some control over it. The accumulated value is not considered part of the grantor's taxable estate, and it can be transferred to the beneficiary of the trust free and clear of gift tax. So it's basically, if you have a family business or a family home that you don't want, that you want to accumulate in value, but you don't want that accumulated value to be part of your estate, you can transfer it to a grit, grat, or groot, name somebody else, usually a child or family member, as the beneficiary of that, and you can allow that accumulated value to not be part of your estate for estate tax purposes. Now, this is a very complex subject, so check out our video and article on grits, grats, and groots on our website if you want to learn more about this. Finally, probably one of the more common uses of irrevocable trust is something called an irrevocable life insurance trust, or an ILIT. And what this does is it removes the death benefit of a life insurance policy from the taxable estate of the owner of the policy. So you change the ownership of the policy from your name as an individual to the trust. The downside is that you can't change how the policy is going to be paid out. You can stop paying on the policy once you transfer it to an irrevocable life insurance trust. The upside is that the payout of that life insurance policy isn't going to be considered part of your estate if it's held by an ILIT. So anyone with estate tax issues or anyone who might qualify for estate tax, an ILIT is really one of the first lines of defense, because if you have a life insurance policy, there's no reason that should be part of your taxable estate. So irrevocable trusts are a broad definition of a certain type of trust that's used for more complex purposes than your standard estate planning revocable living trust. It basically means that you're giving up control of the asset during your lifetime and making the trust permanent and unchangeable, and in exchange you get benefits like estate tax protection and creditor protection. So whenever you're using an irrevocable trust, because it's such a complicated area, you definitely want to work with an attorney who knows what they're doing and can craft an estate strategy that is finely tailored toward your particular goals and situation. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, and you'll be notified of our daily article and video posts. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.